Hello and welcome. I'm Valerie Paley, Senior Vice President, Chief Historian, and Director of the Center for Women's History at the New York Historical Society. Before we begin, I would like to thank Louise Mirror, our President and CEO, Pam Schaffler, Chair of the Board of Trustees, all of our trustees, Joyce B. Cowan, Diane Max, and the late Adam Max, and the Andrew W. Mellon Foundation, along with our Chairman's Council, our members, and our many other generous donors. None of the work at New York Historical Society is possible without your continued and committed support. As many of you know, we launched the Center for Women's History in early 2017. It is the first initiative of its kind in the nation within the walls of a major museum. Now, even during this challenging time of the COVID-19 pandemic, we remain committed to exploring the lives and legacies of women who have shaped and continue to shape the American experience. Which brings me to today's conversation. I am delighted and honored to introduce today's extraordinary panel, Roe v. Wade Revisited, What's at Stake? Michele Goodwin holds the Chancellor's Professorship at the University of California, Irvine, and is the founder and director of the Center for Biotechnology and Global Health Policy and its internationally praised Reproductive Justice Initiative. She is a prolific author and an acclaimed constitutional law scholar and bioethicist. Among her highly acclaimed books is Policing the Womb, which chronicles how women's reproductive health and rights have become the political scapegoat in Congress and legislatures across the US. Professor Goodwin lectures internationally on issues involving constitutional law, human rights, reproductive justice, bioethics, and health law. Kate Shaw is professor of law and the co-director of the Floersheimer Center for Constitutional Democracy at Cardozo Law School. She previously worked in the Obama White House counsel's office and served as a law clerk to Supreme Court Justice Stevens and Judge Posner on the Seventh Circuit. Her work on executive power, the law of democracy, the Supreme Court, and reproductive rights and justice has appeared in a number of law reviews. She recently co-edited the volume Reproductive Rights and Justice Stories with Melissa Murray and Reva Siegel. Professor Shaw serves as an ABC News contributor and co-hosts the Supreme Court podcast, Strict Scrutiny. Mary Ziegler is the Stearns Weaver Miller Professor at Florida State University College of Law. Pulitzer Prize winning historian David Garrow has called her the premier historian of abortion in the post-Roe era. She is the author of Abortion and the Law, In America, Roe v. Wade to the Present, Beyond Abortion, Roe v. Wade and the Fight for Privacy, and After Roe, The Lost History of the Abortion Debate, the winner of the 2014 Harvard University Press Thomas J. Wilson Memorial Prize for Best First Manuscript in any discipline. She often serves as commentator in leading mass media outlets across the world, including the BBC, the New York Times, NPR, PBS NewsHour, the Wall Street Journal, and the Washington Post. Our moderator tonight, Irin Carmon, is a senior correspondent at New York Magazine, a CNN contributor, and co-author of Notorious RBG, The Life and Times of Ruth Bader Ginsburg, which spent 3 months on the Times bestseller list. She's been a national reporter at MSNBC and NBC News, as well as a staff writer at Salon.com and Jezebel.com, covering gender, reproductive rights, and the law. As a contributing writer to the Washington Post's Outlook section, she won a 2018 Mirror Award from the Newhouse School of Syracuse University for her work breaking the story of sexual harassment allegations against Charlie Rose. In 2011, she was one of Forbes 30 Under 30 in media. Welcome, Michele, Kate, Mary, and Irin.
Thank you so much, Valerie. And thank you to my 3 distinguished panelists. You know, it's hard to believe that almost a year ago, we were about to meet in person, not just thinking about everything that's changed in the world since then, but everything that's changed in the world of reproductive rights and justice. So when we were going to meet in the spring of 2020, we were looking forward to the Supreme Court deciding the case in June Medical, which had at its central question how much the Supreme Court was willing to overturn its recent precedent. We'll talk about what the answer was in a moment. Justice Ginsburg, of course, passed away in September of 2020. She was replaced by Justice Amy Coney Barrett, the 3rd justice confirmed by, appointed and confirmed, named by Donald Trump. And we now have a completely transformed court, of course. We barely had a chance to really process what it meant to have a court in which Chief Justice John Roberts was potentially, on some cases, the median vote. So I am so happy to have the three of you to help me and to help our audience process what does it all mean this past year, this of upheaval, in which it would have been impossible to predict all of the turns of events that I just described, exactly how they happened and when they happened, and also help us understand what's to come. So I want to start out, because we have so much ground to cover, I want to start out by asking the three of you, looking back at the events that I just described in 2020, how do you interpret them? Michele, I want to start with you. How do you interpret this shift from this surprise, you can say, decision in June Medical? If you could briefly take us through it, how did you read it? And now that the court is transforming, what does it mean for a decision like June Medical's future?
So one has to read June Medical within the context of the attacks on the judiciary and the legitimacy of the rule of law, keeping in mind that Chief Justice John Roberts joined with the liberals on the court. This is, of course, before Justice Ruth Bader Ginsburg passes away. And his signing on with the liberals on the court represented not his tilt towards abortion rights. He is not a new justice in that way, even though many in the aftermath of that said he's the swing vote. But really, I think part of this is the reflection that there was pressure on the Chief Justice before this with the attacks that had been made by Donald Trump on justices. And Chief Justice John Roberts had to come out and say that, look, there are no such things as Trump judges, as Obama judges, as Bush judges. And the fact that just a few years before in Whole Woman's Health, the Supreme Court had struck down the very laws at stake in June Medical. And it reminded me of thinking about Brown v. Board of Education and Louisiana perhaps saying, or any given state after that saying, well, we're not Topeka, Kansas. So we can segregate all that we want and we don't have to pay attention to this Supreme Court, and we don't have to pay attention to the supremacy of the Supreme Court. On a deeper level, it really is it was a contestation and an attack on the sacredness, really, of the United States Constitution. And in that way, what John Roberts was doing was shoring up the value of precedent, which we could also talk about, and also the legitimacy of the rule of law. And I think that's how one reads the case, and one can't overread John Roberts and a care about women's rights, reproductive rights, or anything more from that case.
Right, and I should say, for those who aren't familiar with the law that was at stake in June Medical, it was precisely as you described. It was nearly identical to a law that the court had struck down in 2016 in Whole Woman's Health. This was a law that said that all clinics had to follow a certain set of regulations that were purportedly protecting women's health, but in effect shut down a lot of clinics. Louisiana passes a law that's basically identical, essentially daring the Supreme Court to uphold it or to strike it down, and to say, if the presidency is different, to your point about legitimacy, which is so important, if the presidency changes, does the understanding of the precedent change as well? Kate, were you surprised by the result in June Medical? And, I had, in our conversations beforehand, I had said, is it going to be a blip because of what happened with the composition of the court that followed? So take me through basically June through November of 2020 and how the ground was shifting.
Sure. Yeah. I think that Michele's overview is exactly right. I think that, so the court divides kind of 4-1-4 in June Medical, right? So 5 justices agree that the Louisiana law, which is materially identical to the Texas law that had been invalidated in 2016, was unconstitutional. So that is a very important sort of bottom line holding in the case. But Roberts writes separately and parts ways pretty dramatically from the 4-justice plurality that's authored by Justice Breyer, who had also been the author of the opinion in Whole Woman's Health, the Texas case. And I think it's right that Roberts is both asserting judicial supremacy, right? Basically saying, not just judicial supremacy, but Supreme Court supremacy, right? We said what we said 4 years ago about a Texas law, and Louisiana has sought to enforce an identical law. And the Fifth Circuit has purported to uphold, even in the face of our precedent, this Louisiana law. So both to policymakers in states and I think to the lower federal courts, John Roberts was saying, we get to say what the law is. So I think that was important institutionally. And also, I think, because the composition of the court had changed since Whole Woman's Health, Justice Kavanaugh had replaced Justice Kennedy. Gorsuch had also replaced Scalia, but that was materially sort of insignificant from the perspective of the outcome in the case. It can't be the case that the public believes that the outcome in an identical case looks different because one member of the court has changed, right? From the perspective of, the court's legitimacy. And so he says a couple of times.
The perspective of John Roberts, right?
This is all the perspective of John Roberts.
How he's thinking right now.
And I think he kind of says it, he doesn't say it explicitly, but he says, the judicial practice and stare decisis as part of our decisional process separates us from the political branches, right? If we just decide what a majority of us want the kind of world to look like, we're not doing anything different from what the political branches do. So that really is something he actually says. It separates us from the political branches. So, right, so that happens. And, I think there are a lot of questions about. So bottom line, I do think it's important. John Roberts had never voted to strike down an abortion restriction previously. I think it's important that he did in this case. I think it was a huge victory for the hardworking lawyers in this case who managed to convince John Roberts to vote with them. I also think it's important that the court rejected this kind of side issue argument in the case that abortion doctors lacked the standing to actually bring these cases to federal courts to decide them at all. So all that's really important. But John Roberts, in the substance of what he wrote, did seem to retreat pretty dramatically from what the court had said about the way future abortion regulations will be scrutinized in the case 4 years earlier in Whole Woman's Health. So that in that case, the court basically said, Planned Parenthood versus Casey, which is post-Roe, the sort of biggest and most important Supreme Court opinion on abortion, says that basically states have a decent amount of latitude to regulate abortion, but they can't do that in a way that creates an undue burden. In other words, places a substantial obstacle in the path of a woman seeking a pre-viability abortion. And Breyer in the 2016 case had said, when we're deciding if a law is an undue burden, we have to ask about the benefits that the law confers and the burdens that it imposes. And Roberts in his concurrence in June Medical really seems to retreat from that description of the court's task in evaluating abortion regulations. And that, I think, is sort of where the action is going to be, at least in the next generation of abortion cases, the meaning of that Roberts concurrence.
This is a question for anybody who wants to take it. That was a differently composed court. Of course, yes, it has. Perhaps the first most dramatic change is the exit of Kennedy, right? That shifts the balance dramatically, but perhaps not as much in the short term as we thought. Then you have Justice Ginsburg replaced by Amy Coney Barrett, who was shaped by the anti-abortion movement. Is the fine point, or the kind of poison pill that you describe, and the appeals to legitimacy that you both beautifully elucidated, do they matter in a world in which they no longer need Chief Justice John Roberts for a majority? Mary, you've chronicled the anti-abortion movement. Is the confirmation of Justice Amy Coney Barrett kind of the consummation of all of their dreams? Will they get what they want, do you think? I say this partly thinking that these trap laws, as they're called in the pro-choice community, these restrictions, I think everybody here knows that they are not actually the favored vehicle of the anti-abortion movement. I mean, I remember going to the oral argument and seeing folks outside from the anti-abortion movement, and their hearts are in the notion of saving babies. Their hearts are not in let's make abortion clinics purportedly safer for the women who have abortions, right? This is just what they thought would win. So I'm wondering, yes, so John Roberts opens up a door. Do they need that door? And what happens now, Mary?
Well, I've always viewed Amy Coney Barrett in a way as a trap for the anti-abortion movement, right? There's, much as there is a GOP establishment and a sort of insurgent or populist wing of the GOP, there is an anti-abortion establishment and an insurgent wing of the anti-abortion movement. Now, the establishment wing of the anti-abortion movement is I think, much more legally sophisticated and has been at this for the better part longer, really, than 50 years. There's lots of DC-based lawyers who have been crafting pretty sophisticated strategies. And as you mentioned, the goal is winning, right? I mean, the ultimate endpoint for both factions of the movement would be an absolute ban on abortion nationwide, right? It wouldn't be overturning Roe and letting the states do what they want. It would be mandating that everybody can't have an abortion regardless of their zip code. But I think the establishment has long understood that that was not going to be an easy sell, not only for John Roberts, but probably for Brett Kavanaugh too in the short term, and arguably even for Amy Coney Barrett. I think the establishment understood too that these concerns about legitimacy, or if you want to be more cynical, a justice's personal legacy would potentially be resonant for other justices beyond the Chief Justice. So I think that there has been a temptation within the movement to believe that the politically and judicially impossible have become possible with the arrival of Amy Coney Barrett. We've seen a kind of, I think, abandonment of caution in state legislation. For example, embraces of, or not embraces of, kind of the opposite, the rejection of rape and incest exceptions, notwithstanding what polling data tell us about what people think about those exceptions nationwide and in deep red states. Recently in Arizona, the embrace of laws explicitly punishing women, which the establishment within the anti-abortion movement has long known is a political non-starter. I think that Amy Coney Barrett made them, believe that they could have and do anything, and that the American public would sign off on it. And that, I think that scares the anti-abortion establishment, which still very much wants to walk through the door that John Roberts opened. The sort of, if you want to be glass half empty about John Roberts' opinion, John Roberts, sort of love story, love letter to precedent was written in an opinion that partially overturned precedent. So a lot of the anti-abortion establishment read that and said, well, this is wonderful because we have a path to undoing things like Roe and Casey without the potential political backlash that frightens someone like John Roberts or Brett Kavanaugh. And what they have working against them now is that the kind of populist wing of the anti-abortion movement doesn't want to wait on John Roberts or Brett Kavanaugh anymore. They want what they want, and they want it right now, and they're not necessarily aware that that could be a trap that could set their movement back.
That's fascinating. I'm thinking a lot about how, you've also written that that trap began to be set when Trump was even elected, that you had total bans passed, for example, in Georgia, that really awoke a political, perhaps semi-dormant political constituency of people who don't want to see abortion banned, but may not be following all of the incremental laws, may hear somebody say that this is about abortion clinic safety and sort of shrugs it if they hear anything at all. So of course, another thing that happened since last year is that, despite fantastical protestations to the contrary, Joe Biden became president. Democrats narrowly, with the help of Black and white progressive voters, narrowly won the Senate. And so we have a bifurcated situation, you could argue, in which certain parts, the executive branch right now is controlled, and Congress is controlled by Democrats, although not powerfully. We're no longer in the realm of talking about, for example, expanding the Supreme Court. We're in the bipartisan commission phase, whatever that'll mean. But of course, state legislatures remain a patchwork that really tends to favor Republicans. And the legacy of Donald Trump's presidency is in these federal courts. Both, we've been talking about the Supreme Court, but of course, many of these laws will never see the Supreme Court. They will work their way up lower federal courts and appeals courts. And Donald Trump has put a indelible stamp on those. So given that, where do each of you see the path forward for each of these movements? Just thinking about them, from a detached, or not from a detached, but looking at them in terms of your predictive analytical powers. So Mary, you talked about overreach. What do you think is going to happen with respect to the limited power that the Democrats and the pro-choice movement, which are obviously not the same thing, have moving forward, given what's going on with both the Supreme Court and the lower federal courts? I'm not going to be one of those people that says, oh, well, the Democrats overreach, but what can they actually do?
Well, I think there's a sort of weird relationship between what the Democrats can do nationally, right? I mean, one of the things that we tend to ignore is what Democrats can do at the state level, because of course, the story really, I think, of the past 50 years in many ways has been that the anti-abortion movement has been much more nimble in state legislatures than the pro-choice movement has. And I think that we're beginning to see that swing back the other way a little bit. So that's probably the lowest hanging fruit for Democrats, and probably the most realistic and least risky. I think there are lots of other steps that we can all talk about. There's federal legislation protecting abortion rights, which Joe Biden has kind of floated, saying he wants to codify Roe v. Wade, although we don't really know what he means by that, because when people say Roe v. Wade, they mean lots of different things. Does he mean like a robust concept of reproductive justice? Does he mean just a right to abortion? Does he mean actually like Roe v. Wade or actually what we have now? We don't know. But some kind of federal legislation. We know that he could take steps to make it easier for patients to access medication abortion. We know that he's hoping to leave an imprint on the federal judiciary, which would of course have a significant impact because, as you mentioned, plenty of abortion restrictions never even make it to the US Supreme Court. I'm sure he's hoping to leave an imprint on the US Supreme Court too, whether that comes in the form of replacing Justice Breyer or potentially replacing someone who retires or passes away unexpectedly. I think there's even been talk, of course, of changing the composition of the court or adding justices to the court. There are questions about how much some of those federal steps would be a priority for the Biden administration. I think at the height of a pandemic and a recession and a crisis of racial justice, there's lots of things wrong, essentially, that the Biden administration wants to deal with. And it's not clear whether federal abortion legislation or adding justices to the court would be a priority. I think what makes it unpredictable is the Supreme Court, because we know that there, or at least we begin to suspect that there are different conservative factions on the Supreme Court. There's one faction, as Kate and Michele mentioned, sort of represented by Chief Justice Roberts, that's a more sort of institutionalist faction. And then there's, I think, a more sort of extreme throw down the gauntlet version of conservatism embodied by Justice Thomas and Justice Alito. We don't know where the other justices will land, but if the court were to kind of go more on the path forged by Justices Thomas and Alito, the probability of something like a federal abortion law or additional justices on the Supreme Court would go up exponentially, in my opinion. I think that would give, I think, more of a push to Democrats to be more aggressive and expend political capital on this issue when they might otherwise hesitate.
Michele, how do you see it in terms of this dynamic of Democrats, and to some extent progressives controlling Congress and the White House, and yet the federal courts are what they are? What kind of progress with respect to expanding reproductive rights and justice is possible? Let's talk about it at the national level.
Right. So let me say this. I only wish that there was greater attention to the very progressive work that Jimmy Carter did, right? To sort of think about Jimmy Carter and expanding the face of women on our federal bench, including Ruth Bader Ginsburg coming from the ACLU, right? I mean, like, look at that, right? I mean, in and of itself says so very much. But to put some context and brackets around this, we have Trump being able to nominate and then confirmed through a McConnell Senate more federal judges than any other president save George Washington during his time in office. And what this looks like racially is inconsistent with what we had seen in presidents before. Before he left office, of those that were at the federal appellate bench, there was not one, at least as of August before November, not one was Black in terms of a federal appeals court judge. Very few Latinos, mostly white men, right? So really moving away from a trend that had started in robust ways with Carter, and then the ball drops a bit with Reagan, but certainly in terms of President Obama, right? Stark contrast there. So I think the movement afoot will have to be more concentration on the courts. And I think it's good that Biden is setting up a commission to think about the role of the courts, expansion of the courts, perhaps, or exactly how do Democrats get themselves around thinking about the importance of the courts, which has really not been an issue that they've emphasized. Now, as to the points that Mary has raised, which I think are so critically important, and I want to take us back to Chief Justice John Roberts and this split. So in the face of the decisions like June Medical, Bostock, you have Roberts drawing this ire of conservatives, including Vice President Mike Pence, who actually says that the Chief Justice is a disappointment to conservatives, quote. And he specifically singles out the ruling in June Medical, and he actually says that this is then a quote, wake-up call for pro-life voters around the country who understand in a very real sense the destiny of the Supreme Court, and that it's on the ballot in 2020. Well, for them, it's always on the ballot. But to express even more, you have Ted Cruz, who's saying that, who compares John Roberts to being in a swamp, to being engaged in swamp infected politics on the court. I mean, you can't get more visceral in terms of the attack that comes after June Medical. So I do think that there are these fractions, and we see these fractions and factions on the Supreme Court, and we see this within the broader movement of the anti-choice movement. What this means in terms of politics in the court, one would only hope that not only at the federal level is there greater attention to these issues by Biden and also by Congress, but let's also say that at the state level, these issues remain important too, both legislatively and also within state judiciaries. And we saw that with the backdrop of Wisconsin, and we see that in Alabama and all of these other states. So I'll end there, but there's so much more to be said just on those points.
Right. Yes. No, I feel like I would take a class taught by each of you, or ideally together, honestly, because I think all of your insights are working together like a beautiful puzzle. So one thing that Kate, just staying on this question of the Democrats and the pro-choice movement at this particular moment, one thing that I wondered was whether the combination of the events we just described during the Trump administration and the death of Justice Ginsburg being a kind of mobilization, the Merrick Garland nomination, which we haven't talked about, but I think everybody listening will remember, has that changed both the Democratic electorate and Democratic legal elites' approach to these questions, of which one of many issues that of urgency is abortion, but it's not the only one. You worked in the Obama White House. You're aware that there was a lot of frustration with how Obama did or didn't prioritize the judiciary, especially compared to what followed. Do you think it's different now? And if so, how does that play out with respect to reproductive rights issues in the courts?
I do think probably the last 4 years and the treatment of Merrick Garland during the last year of the Obama administration has probably been radicalizing to a degree, and maybe correctly so, on the courts for a lot of institutional Democrats. I think that it's right. There was a lot of, I think, very fair criticism of the slow pace of judicial nominations, in particular in the first couple of years of the Obama administration. And the administration never really caught up to the pace that Trump basically maintained for the entirety of his 4 years. I mean, I think that the decisions were, taken very carefully. I think that the administration was rightly proud of the diversity achievements that we were able to make on judicial nominations. And it actually meant going looking sort of outside of the ordinary channels for the production of federal judges. And sometimes that took time, and sometimes it meant judges who were in their 40s or their early 50s. And I hope that those priorities don't fall by the wayside, right? Seeking out from unexpected quarters judicial nominees, sometimes being willing, if it takes a couple of decades to build the kind of career in public interest that it sometimes takes in order to get on the radars of senators or White House staffers looking for judges. I hope that we don't disqualify those individuals because the youth imperative, which I think has rightly been highlighted in sort of recent days and weeks and months, is sort of brought to the fore. So I think that I hope that the lesson of Trump is that it's important to move really fast and prioritize judges, even as you're prioritizing a legislative agenda, because your legislative agenda won't survive even if you get it enacted if you haven't focused on judges. And so I hope that takes the form of kind of early and aggressive nominations and the willingness to bypass some of the kind of slow walking sort of courtesies that, outside review and senatorial consultation and many of the kind of institutional norms that the Obama administration adhered to, I think out of a sense of humility. These things are well settled. Many generations have sort of utilized these processes. The Trump administration didn't care. Yeah, please.
Do you think and quick follow-up, because there's one big question that I want to ask that I want to make sure we get good time for, but do you think that in Amy Coney Barrett with her avowed anti-abortion views, you have Lindsey Graham saying at her hearing that she's a role model for the pro-life movement? Would her equivalent now be nominated by Biden, given, the kind of the fact that Democrats would not be nominated if they had paper trails, for example, like writing a memo about Mumia Abu Jamal. That's a legislative, an agency example. But there were so many people who were disqualified. Don Johnson, that's a good example of somebody who was disqualified essentially because of their views about reproductive rights. Are they going to care about that now?
Well, so let me say, like, Dawn wasn't disqualified. She was nominated, right? The president chose her. She wasn't confirmed.
That's true.
So,
that's true.
I do think
I'm sure there are other ones whose names I don't know.
No, but I think it's right. So she was nominated to head the Office of Legal Counsel, sat for a year plus, if I'm not mistaken, and eventually withdrew her name. So I don't know the answer. I hope. Yeah, but
I guess we can see if congressional Democrats also treat these things differently after the kind of, because what we're really talking about here is how explicit are these nominees, whether they are to agency or to executive office, or whether they're for lifetime appointments in the judiciary. How explicit are they allowed to be if they're pro-life, quote unquote, or if they identify as pro-choice? Okay, so here's a question that I want to ask, that I want to figure out how to ask correctly. Clarence Thomas wrote a concurrence in a procedural motion, decision on a procedural motion in Indiana law that banned abortion for specific reasons, including race. And Melissa Murray, who is a colleague of Kate's and well-known and respected by all of us, has written about how Clarence Thomas may have been laying out a roadmap in which race and racism are specifically deployed as tools to undercut abortion rights. So by saying that somehow a right to access an abortion is itself racist, it's taking the power and the urgency of anti-racism in the service of limiting abortion rights. Contrast that with the fact that one of the dynamics that we're talking about here with respect to what's changed with Democrats is that even Joe Biden, who had been a defender of the Hyde Amendment for a long time, saw himself during the campaign kind of changing his mind, I guess, saying that he was, who knows what he's going to do now that, his press secretary can barely say the words. But at least the pro-choice movement and reproductive justice advocates had managed to make it impossible for a nominee to robustly defend the Hyde Amendment because of the way that the ban on Medicaid coverage for abortion disproportionately harms low-income women and specifically women of color. So you have each movement making arguments and claims about the racial ramifications of access to abortion and to contraception. Moving forward, how do you think, given that the country seemingly having to learn this lesson again and again and again about racial inequality in our country, how are those intersections going to play out, do you think, at the legal and legislative levels? And I'm going to open up the floor to whoever wants to jump in first.
Well, let me just say that you're absolutely right in tapping into and citing this work of Melissa Murray's in terms of Justice Thomas using this as a strategic moment. But he's not alone. He's actually building on a more recent legacy and then a longer legacy. So the more recent legacy has been dating back to about a decade with states proposing, and even there being some congressional proposals. Frederick Douglass, of all things, naming this kind of legislation after Frederick Douglass, right, to protect women of color from themselves if they're seeking to have an abortion, basically situating abortion itself, if you are a woman of color, as being something that is a genocidal premise, something that the law should intervene against. It's another tool that's weaponized within the anti-abortion arsenal. But in terms of a longer agenda that I think is important to be in conversation with this is that the very origins of anti-abortion movements were deeply racialized. It's no surprise that when you look at anti-contraceptive laws, the law undergirding the Griswold case, you look at when these laws are enacted and you find that these are Reconstruction era or Civil War era legislation that's being proposed. And specifically with those who are pushing it from the medical end, they're using this language of needing white women to give birth. They are actually saying we need white women to use their loins and to go all across the country because of this fear that now that slavery is over, will be overpopulated by these people of color and by Black people. And so this is actually a longer agenda of using the euphemistic football of Black people and other people of color, their reproduction, as a political tool. This has never been a country that has actually invested in the care with regard to the health and the safety of Black women or their offspring. That's never been the case. And you notice with these anti-abortion movements, that's still not the case, right? It's being used as a kind of leverage to just simply stop what is otherwise a constitutional right that has been that is now due to women of color. In short version.
Yeah, and if I could just jump in and say, so to connect, Melissa makes this very insightful kind of doctrinal point about stare decisis, both in she's written about this in a few places, and she's got a piece coming out later this year in the Harvard Law Review. But she basically says that, the court has long held in Casey and in many other opinions, both in and beyond the reproductive rights context, that overturning a prior case requires some special justification, apart from just 5 members of the court think the earlier case was incorrectly decided. And that what Thomas seems to be doing in his concurrence in Box is laying the foundation for what he argues are sort of the racist origins, the eugenics origins of abortion access laws. He says early abortion is essentially a tool of deracination, right? To sort of argue that this version of history that he's advancing in Box supplies the special justification for revisiting the court's earlier cases. So that again, it could be consistent. You could overturn Roe and Casey, and do that by pointing to this, extremely historically contested account that he is offering, but do it in a principled way that doesn't look just like, well, 5 of us have a different vision of the good, and we're going to jettison these prior cases. So, if she's right predictively, I think it's an extremely savvy strategy, and we don't yet know how it's going to play out. But that, I think is what he is arguably sort of laying the kind of foundations for in Box.
Right, and I think we're about to see, sorry, go ahead.
And if we could just be clear on the eugenics point of this, right? So 1927, the United States Supreme Court upholds a Virginia law that is a eugenics law, and it's a test case essentially. And this is a test case that's actually about a young white woman who at 16 years old had been raped and gave birth out of wedlock to a child. So even the very premise of what upholds U.S. eugenics law in the United States has actually nothing to do with Black women, women of Asian descent, or Indigenous women, or Latinx women. It is actually, an enterprise that the United States begins, much like in Germany, which took note from the United States. And it is really about ridding the United States early on. It expands, but early on, it's about ridding the United States of white people that are considered to be socially and morally and otherwise unfit. And so I think being
evil-minded, I think that's the word in there.
Exactly.
Yeah.
They're being clear to that historical origin.
Is the name of the case, right?
It's Buck v. Bell, yes.
Yeah. Mary, based on your perspective of the movement, Clarence Thomas is writing alone in the concurrence that we're talking about, but he's obviously drawing on these historical and movement forces. What kind of purchase do you think these sort of, we call them reasons bans, right? That they also bring, they seek to exploit divisions around abortion related to disability diagnoses, for example. We've talked a lot about the race aspect of this, using the power of anti-racist movements, twisting it on its head, you could argue. How resonant are these inside the anti-abortion movement? And do you expect that this would be sort of a primary lever of undermining the existing jurisprudence at the Supreme Court?
I think more so after Clarence Thomas's concurrence, but the challenge, of course, is that the anti-abortion movement doesn't really care about reasons bans because they don't actually criminalize many abortions. I mean, the only potential power of them is that they're kind of the Hyde Amendment for everyone, right? The Hyde Amendment is in effect a reasons ban for low-income women who have to justify themselves on the basis of having been sexually assaulted or a health condition. This expands the logic of the Hyde Amendment, and also within the anti-abortion movement, the hope would be the effect of the Hyde Amendment, which was to functionally discourage all low-income women from even seeking abortions. But of course, the challenge, I think, is that you see this popping up, that anytime a reasons ban is being introduced, for example, in Tennessee, so too is, you know, a heartbeat bill or an absolute ban or a law suggesting the death penalty, because that, not the death penalty per se, but absolute bans are really what get people in the anti-abortion movement out of bed in the morning. Reasons bans are a strategy. And I would say not even necessarily the main strategy of the folks who are looking primarily to win, many of whom are focusing, I think, significantly on later abortions, right? Specific techniques, abortion medication and limiting access to it.
Yeah, something that's been very important during the pandemic.
Exactly, yeah. So I think that while reasons bans are significant, it's worth not losing sight of the fact that for the anti-abortion movement, this has very much always been a kind of throw things against the wall and see what sticks strategy. And it's also worth not losing sight of the fact that this has never been about what they really care about. So as soon as they are convinced that they can get what they want, they will ask for it. And they already have begun to do that, right? I think notwithstanding the fact that polling data would tell us that it's unwise for them to do so.
Well, I mean, it sounds like you're saying that there's a risk for them in overplaying their hand when the majority of the public polls over and over again say, and of course it depends how you ask them, but the polls do show at least a popular support for broadly abortion rights. It sounds like you think that potentially this movement is going to overreach with the levers of power that it does have.
Yeah, and I think even in the states, for example, I live in Florida, I'm surrounded by Alabama and Georgia. In those states, when they are able to ban abortion, if they do, for example, choose to formally punish women, that probably isn't going to be particularly popular in those deep red states. There's, I think, a sense in which Trump has convinced some people within the movement either that the opinion of the public doesn't matter or that the public will simply come along regardless of what they actually request. And that's dangerous, even in deep red states. And it's certainly dangerous at the national level if you're thinking about the response of the Supreme Court or even folks in Congress. So I think the lesson of the past 50 years for me in a way is that there is no permanent victory in this conflict, or there has not been one. And I think that people in the pro-choice movement forgot that when Roe came down. And now people in the anti-abortion movement are in danger of, it seems, I think, have already forgotten that and believing that a conservative Supreme Court can end this debate once and for all, which I think, of course, is impossible.
Well, you've led me perfectly to our close. I have to say, I would completely take a class with the three of you co-teaching. I have to say that I've also been covering this for more than a decade, and yet tonight I've learned so much, and I'm thinking a lot. I'm kind of chewing over things that each of you said that have led me to see things differently from how I did before. And I can't think of any better way to end a panel than to say thank you for teaching me. I appreciate it.
Thank you so much.
Thank you so much.
And thank you all very much. I want to thank Michele Goodwin, Kate Shaw, Mary Ziegler, and Irin Carmon for being with us today. What an amazing panel. Please sign up for our mailing list and follow us at nyhistory.org to get the latest on upcoming programs. Finally, we hope to see you back on Central Park West to view Cover Story, Katharine Graham, CEO, opening April 16th in our Joyce B. Cowan Women's History Gallery. And in the fall, we'll be presenting Notorious RBG, the exhibition. Lots to come back to New York Historical Society for. So we will see you there. Thank you and good night.